Wednesday night, the Illinois Legislature ratified the Equal Rights Amendment, or ERA, becoming the 37th state to do so. Wait, didn't the deadline for ratifying the ERA expire back in 1982? I'm Robin Kinderman, and you're watching JBS Straight Talk. For those of you under 50-something, the ERA was introduced in Congress in 1971 amidst the feminist movement. It states that equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. It was approved by the House of Representatives and sent to the U.S. Senate, who passed it on March 22, 1972. From there, 38 states needed to ratify it. Originally, Congress stipulated a ratification deadline of March 22, 1979. Between 1972 and 1977, 35 states ratified the amendment. However, prior to the 1979 deadline, Idaho, Kentucky, Nebraska, and Tennessee rescinded their ratifications, knocking the total down to 31. This did not sit well with ERA proponents, so they argued that states cannot legally rescind the ratification of a proposed constitutional amendment. What? That would mean that future legislatures can never undo the actions or laws passed by a previous legislature, no matter how bad or unconstitutional they are. Basically, one vote, one time. That in itself is unconstitutional. As the 1979 deadline approached, ERA activists pushed Congress to pass an extension, and President Jimmy Carter approved it. The new deadline became June 30th, 1982. Between 79 and 82, not a single state ratified the ERA. So without 38 states to ratify the ERA by its deadline, it should no longer be valid. However, proponents say that both the 79 and 82 deadlines don't matter. How is that possible? If the original 1979 deadline didn't matter, why was an extended deadline resolution passed by Congress and signed by President Carter? It obviously mattered then. And now that several decades have passed since even the extended deadline, how can any state legally ratify the Equal Rights Amendment now? So what about the ERA itself? Many assume that the ERA somehow puts women in the Constitution. However, the text doesn't even mention women. Instead, it uses the word sex. Let's think about this. The word sex does not just define gender. The meaning of the word can be defined several ways. Imagine how our courts would interpret the meaning of just the word alone. The ERA would virtually turn the 10th Amendment on its head by transferring the jurisdiction and powers of laws that relate to family, like marriage, divorce, adoption, abortion, alimony, public and private education, even restrooms and dressing facilities, away from state and local governments to the federal government. The potential ramifications are huge. Even though there are obvious shortcomings with the ERA and the deadlines have already passed, we should not underestimate the power of the deep state-controlled Congress and courts to get and keep what they want. For these reasons, we encourage the remaining states that have never ratified the ERA to oppose any and all attempts of ratifying it now or in 2019. Furthermore, we also encourage those of you living in states that have passed the ratification to contact your state legislature and ask them to introduce and pass a rescission resolution. And to the ERA folks, we say, if rescissions don't matter then, don't worry about trying to stop them from passing. To stay up to date on all things constitutional, including the ERA battle, head over to thenewamerican.com for daily articles. Until next time, take care and God bless.